Yea. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting in Boston, within and before the Commonwealth. Draw near, give attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning, everyone, and welcome to this sitting of the Massachusetts Appeals Court. It is my great privilege, except that I've rolled over my robe, it is my great privilege to be sitting this morning with Justices Shin and Hodgens, and my name is Gabrielle Wolohojian. For those of you who have been here before, I apologize for repeating some of the ground rules, but I'm going to give just a few of our basic protocols. I will try to remind you if your case is fully or partially impounded so that you and we all can remember not to use, it's usually the parties' names or people's names in open court. You can refer to them by their status in the litigation, such as the child or the wife. Each side receives 15 minutes to argue. There's no rebuttal, so don't reserve time for rebuttal. The timer on the podium will display a yellow light a minute and a half from the end of your argument so that you know that you have a minute and a half to wrap up. We try to, but this is no guarantee, hold off on questioning you too much during that period so you can wrap up your argument as you'd like. And when the red light goes off, your time is really up, unless the panel has more questions for you. You are free to structure your argument any way you'd like. However, rest assured that the panel has already read your briefs, the pertinent parts of the appendices, and the transcripts. And so you don't need to feel like you need to educate us about what your case is about. You can leap in to your argument wherever you'd like because we are prepared. And with that, and I anticipate that we'll take a fairly brief, like 10 to 15 minute recess after the third case this morning. So if you're planning further ahead than that, just so you know. So our first case this morning is 2022 P0219, Commonwealth versus Terrance Montgomery. And is it Attorney Demond?
Yes.
Did I pronounce that correctly?
Demond.
Demond.
Close.
I'm so sorry. Thank you.
No worries. Thank you.
We are ready whenever you are. My docket sheet here notes that it is the case is partially impounded.
Thank you. Yes. Good morning, Your Honors. May it please the Court. My name is Sharon Demond, and I represent Mr. Terrance Montgomery. I think the issues in this case are very much intertwined, and I would like to tailor my argument as they come up that way, if I may. This case starts off on unequal footing, where the Commonwealth is allowed, with the aid of the trial judge and without objection from trial counsel, to essentially weed out every single juror that was concerned or did not unequivocally commit to convicting the defendant based on Commonwealth's evidence, but more importantly, based on lack of forensic evidence. Essentially, the jurors were impaneled who said that they're willing not to consider the lack of forensic evidence when they are determining guilt beyond the reasonable doubt.
May I ask you a question? Was every juror asked the identical question?
They were not identical,
Right.
but every
I
single
noticed that
juror.
too. And don't you think that the only relevant inquiry for us right now is about the jurors who actually deliberated on the case?
No, Your Honor, I don't agree with that. I think it's
Why?
important to consider the jurors that were excused as well, because essentially the
But at some point, you're going to have to establish prejudice.
Yes.
So how are you going to establish any prejudice with respect to any juror other than one who deliberated on your client's case?
So this is how I will establish prejudice, is that two things. One is that the jurors that were not impaneled and the jurors that were impaneled, the jury we got was not the jury that we were going to have had this question not been posed.
So is there any case, I'm looking for a case site here,
I'm sorry?
I'm looking for a case cite. Is there any case that uses what you just articulated as the measure of prejudice in a similar case?
Well,
I'm looking for a case cite.
yes, there is not exactly a case on point.
Okay,
but I
so
would
what
suggest-
case, what is the measure of prejudice that
So-
the cases, and you'll give me a case cite for it, that the cases give?
Two cases come to mind, Your Honor, that is not directly on point, but will get there. The first case is COMMONWEALTH v. Serrano, which was cited by a panel of this court, cited in our brief. In that particular case, the panel found that the question was impermissible. However, the only reason they didn't find prejudice was because no jurors were excused. So I will say conversely, if you were to look at that and say, okay, where is the prejudice? Now, this is one of the ways that I will show the court prejudice, but just to directly answer Your Honor's question,
Yeah.
is that when you look at that case and you look at how it wasn't prejudicial, how the panel came to the fact that it wasn't prejudicial, was because no jurors were excused based on that fact. Conversely, in this case, every single juror was excused based on that fact.
Okay,
The
but
other-
there's a logical problem with that, because you haven't shown anything whatsoever with respect to the excused jurors.
So with respect to excused jurors,
Yeah.
they essentially said,
Because there were jurors excused for many, many reasons in this case. I read the entire voir dire.
thank you, Your Honor. But if you look at, I tried to be helpful with a chart that I made during the motion for a new trial, and in the memo for the motion for a new trial, I made a chart of every juror that the minute they said they are not equivocally going to convict, they were excused based on that.
I think we need to be precise. The question used the word convict,
Yes.
but it didn't look for a commitment. Okay, so that's why we need to be precise about what the language of the question was.
But Your Honor, how
It
can it
didn't-
not? How can it not?
Well,
It did use
let's
the.
go. Let's
Okay.
go question by question. Why don't you point to me, because they're not identical questions.
Okay, yes. However, if you look at what they have in common,
Yeah.
for example, if you look at juror number 59, where the question is, would you be able to convict somebody just without forensic evidence if there were other evidence that satisfied you? Would you require DNA or fingerprint evidence, even if they were other evidence that you believe? The juror answered, I don't know, I have no idea. So again, not committing, but not knowing, right? So then this particular juror, the trial judge chimes in now and says, well, in this particular case, you're likely to hear testimony as to eyewitness account as to the shooting, okay?
Yeah.
Would the eyewitness evidence, as we call it, be sufficient in your mind? So, Your Honor, essentially, we're telling the jurors one by one, Commonwealth has this evidence, and the evidence is eyewitness with the testimony. The Commonwealth doesn't have forensic evidence. Are you willing to convict based on what Commonwealth has? I mean, it's essentially the juror saying, yes, I'm willing to convict based on what you have. They get impaneled. They said, I don't know,
really
maybe.
confused. I'm really confused about your focus on the Venere people who were excused.
Okay.
Because
if
I
we-
can't attach that. What is the, I thought you were making a constitutional claim that
Yes.
you did not receive a fair and impartial jury.
Yes.
That's the foundational principle, I think, for your claim.
Correct.
Why is it that we don't focus on the jury that you had rather than the jury that you didn't have when we're assessing that? And do you have a case that says that we would look at the jurors you didn't have in order to determine whether or not the jury you did have was composed of fair and impartial jury people?
Okay. Let's focus on the jurors we do have. Okay.
I think that
So-
for me, that would be, I think, more helpful.
Okay, so one in particular comes to mind, and that'll be juror number 5, where the juror starts by saying that maybe maybe I'll consider that. Then right after the trial judge chimes in again and sort of focuses the question, juror number 5 says, oh yeah, I can do that. And then juror number 5 is impaneled and is
I
deliberating.
didn't see that. I have the quotation for juror 5 in front of me. What I have is question, and do you think you would have a problem convicting somebody of a serious crime without forensic evidence or scientific evidence like DNA or fingerprints? Answer, inaudible something. That's a tough one, inaudible witness. Question, I'm sorry. Answer, I think I would need beyond a reasonable doubt with some compelling evidence, yeah, before I could convict someone of first-degree murder. That seems to me like a completely helpful and accurate statement from the prospective juror. Question, well, I think in this case, it's fair to say that the evidence that the Commonwealth anticipates introducing relates to eyewitness accounts of, answer, oh, that could be compelling evidence.
So,
Okay, so I don't hear, oh yeah, and sure, or it's important that we stick to what the transcript actually says.
okay, I understand, and I apologize, that was my edification of it, but even if you take all that and look at face value of that, where the juror originally is not so sure and the juror is not saying yes, then right after the judge poses the question, the juror says, yes, I can do that. Or however, I don't have the quote in front of me.
No, that's not what the juror says. The juror says, oh, that could be compelling evidence. I don't see the juror saying yes. If the juror said yes, just correct me and give me the line of the transcript.
Your Honor, could be, what I would suggest, is essentially the same thing when you're removing the consideration of forensic evidence. Now, any case you look at essentially said that the message has to be neutral. The message has to be, are you willing to weigh the evidence? Are you willing to consider the evidence? It needs to be neutral. This is not a neutral question. Even if you take everything else away, the word convict was essentially denounced by the court in Maryland, Charles v. State, and that language was, if you will, adopted by the SJC referred to that case with approval. Now, most recently, in Brown case, to answer your Honor's question whether or not there's a case about prejudice, in Commonwealth v. Brown, again, the Supreme Judicial Court upheld the case, but they upheld it because of two things. First, they said the preemptory challenges were used, no jurors were excused, again. And secondly, they said the lack of CSI evidence was not removed from consideration. However, the court did go on to say, don't use the word need, or not maybe in these words, but they said essentially need best be avoided.
Are you suggesting that the voir dire questions have the equivalent of a jury instruction?
Well, I'm suggesting the voir dire question, in addition to how the judge, the trial judge in this case, focused them on the Commonwealth's evidence, essentially would, because they're essentially asking the jurors, are you willing not to consider this evidence, but this evidence? So essentially, it's messaging.
How did the judge focus them on that?
There were a number of times where the trial judge tried to make this more understandable,
But
more comprehensible.
was that with respect to any juror who was seated?
I believe and I'm sorry, I don't have those sites in front of me.
Right, I don't think so. I didn't see that.
Well, juror number 5 is one, right, that the court asked the question.
I didn't see that either.
I apologize. I can come back and I can.
We don't need to get bogged down
60
on that because the transcript is what the transcript is.
Absolutely.
But none of the questions uses the word need.
No, it doesn't.
None of the
Yes,
questions
no.
uses the word must.
No, correct.
And so Judge Hodgens' question is where there's no instruction embedded in the question. Why would, or do you think that the voir dire question is akin to an instruction on the law to the jurors?
Because of the word convict and because of the narrowing of the Commonwealth's evidence. So because even if I don't have the precise question in front of me where the court chimed in, but the court did tell the Commonwealth to focus your questions number of times as to what the evidence you have.
So how do you distinguish Andrade, where the question was, would the lack of eyewitness testimony prevent you from finding the defendant guilty? How is that different?
I'm sorry, can you repeat?
In Andrade, the question was, would the lack of eyewitness testimony, quote, prevent you from finding the defendant guilty? Isn't that the equivalent of convict?
No, I would suggest to the court is the opposite. It gears towards finding the defendant not guilty rather than convicting. So it's conversely asking the question whether or not you're going to do this, but this particular question is the word convict, which is the focus. And that very word was the focus of the Maryland court in Charles v. State, where the court said that messaging, if you will. And to go back to the question of Justice Hodgens, is that that word in and of itself has a non-neutral messaging, never mind the context that it's put in. Now, if I may just move to the prejudice prong of this, is that the trial judge who was also the motion judge who was also the trial judge essentially held this kind of questioning was impermissible, but he didn't find prejudice because of two reasons. And those two reasons were that the jurors seated were impartial and not biased, and secondly, that there was overwhelming Commonwealth's evidence. Now, I would suggest to the court that that does not track the evidence in this case, where the Commonwealth did not have overwhelming evidence. What the Commonwealth has was eyewitness testimony, and two of those eyewitnesses, now aside from the fact that those eyewitnesses essentially testified under grant of immunity or cooperation agreements, setting that aside, those witnesses essentially testified that the deceased was shot while he was walking away, and one in particular said the deceased was heading towards me, was facing me with his back towards the defendant.
Why would we assess prejudice based on the strength of the evidence? I don't understand that.
Because there is no strength in the evidence. The strength in the evidence is misconception of the evidence.
The question is
track.
whether the defendant got a fair and impartial jury. I don't really. It doesn't track to me to then look at the strength of the evidence. The question is whether the jury was fair and impartial.
Well, if that is how this, obviously, the motion judge's finding is not final, and I understand this court is the final arbitrator here, but what I'm trying to get across is that the prejudice that the judge did not find, or the motion judge did not find, was very much reflected in the evidence, where the fact of this case was the deceased was shot in the face. The testimony was that he was shot while walking away, and he was shot when he was facing...
I read your brief to almost be saying that it's structural error. Once we find that the question was improper, we assume that the composition of the jury wasn't fair. Is that what you're saying?
I'm arguing both. I'm arguing the alternative. If you find that way, then obviously that's fine, and the motion for a new trial should be granted. If not, in the alternative, then we're talking about the fact that there was indeed prejudice in this case, and there are also other issues that, like I said, is intertwined with this, where the witness was able to get refreshed without proper procedure, essentially coaxing to testify how the Commonwealth wanted her to testify, and then the Commonwealth wrapping that up in a nice little package during his closing argument, and then to boot, having the cross-examination halted because of the privilege against self-incrimination directly connected to this shooting. So I'm sorry, I didn't get to my other issues, and I see I'm out of time.
I know your time is up, but I would like you to turn, if you don't mind, to your last argument in your brief. And this is the argument about once the witness asserts the Fifth Amendment on cross-examination. So I have two questions for you, really. The first is, there was no sort of offer of proof made during the trial. What was it that you say defense counsel would have inquired of into with this witness, that the assertion of the fifth precluded? Is it the contents of the video? What is it? What was it?
It's the witness's bias plus the content of the video. So
Okay,
we
so
have a-
no one knows what the content of the video is, so I don't know where that really gets you on that one, right? Because there's nothing to suggest that anyone knows what the content of the video was.
we do know the content of the video was the events that were surrounding. At a minimum, the
From
content
the
of the
perspective of the person on the porch next door.
Yes. The content of the video, at a minimum, would have the people present at the party.
Right, so but there was no defense that, there wasn't an alternate shooter defense in the case.
Well, yeah. I mean, if the defense
I
was
understand.
misidentification or purposefully identifying the defendant to cover up for someone
Yeah.
else, then definitely who was on that video is utmost important. Not to mention the fact that she incurred robbery charges, assault and battery charges.
That all came out.
Right, yes, but the underlying facts of the robbery and why her bias in doing that did
But
not
her
come out.
bias came out too, because the judge allowed you to cross-examine her on her bias, including that she really disliked your client.
Yes, but not who she was covering up for. People that were present, one
But
of
there
which was
was
her brother.
there was no question about that, was there?
Well,
You
her
could have
brother was-
asked that, and they didn't. The judge didn't restrict cross-examination into bias.
Bias towards the defendant, correct. However, the motive to lie was never
It wasn't
never
inquired
explored.
into. Yeah,
sorry?
it wasn't inquired into.
But essentially the judge said any facts surrounding this robbery or this assault you can't go into. So the facts would be that she was on the porch fighting over before he was recording. She was there with her brother fighting with the neighbors. Then within a 5-minute span of time, she leaves the porch, watches her in-laws empty the car, then makes it to the backyard, witnesses the shooting, then is back on the porch fighting over the phone, and indeed takes the phone and it pings from inside of the house. So how would that possibly jive with her seeing this shooting and then trying to get the phone away?
But didn't that all come out through the testimony of Cynthia Martinez? In other words, another witness testified to all that and effectively impeached her.
Well,
right?
no, the other witness testified that she came on the porch, fought her husband and took the phone away, right? But the facts, the underlying facts as to who was she trying to protect? Why was she up there? Why is she taking the phone away during this whole melee? The underlying facts of that robbery. And that becomes most important because when she's originally interviewed by the police, she said, I saw nothing, I wasn't in the backyard. She gets charged, and all of a sudden she has this epiphany of who she saw, who the shooter was, what her testimony was, and she comes forward only after the charges. Now, once you're charged, obviously your motives have changed, you have a big incentive to lie, not to mention that she was violated on her probation at least 4 times prior to the trial, and all 4 times the Commonwealth shows up and reduces the restrictions of her probation. Finally, all restrictions are lifted, all conditions of probation are lifted because of the Commonwealth. The day after conviction, her charges are null pros. So I would suggest that at a minimum, her partial testimony as for identification should have been stricken, not to mention her entire testimony. I think her testimony is squarely jives with the holdings of Commonwealth v. Joyce and the other cases we cited in our brief where the court essentially says, Commonwealth v. Connor, I'm sorry, now comes to mind, where the court says, all right, there is bias when your testimony all of a sudden appears after you're charged and then you have an agreement and then you start testifying. This is sort of follows that route where the witness now all of a sudden while being held in prison and charged says, okay, I remember everything, and now we have testimony that she can't be crossed about.
Okay,
Why
let
is
me
it?
look and see if there are any other questions. No, thank you. Your time has expired and we have your argument. We'll have to leave it there.
Good morning. May it please the court. David Shepard Brick on behalf of the Commonwealth. I guess I'll start where defense counsel left off. And to address that, I would say all of that came out. All of her bias, all of everything that the prosecutor did for her in terms of getting her out of, violations of her pretrial release conditions, all of that came, all of the things, I mean, the no pros, which happened after the case, didn't come out because it hadn't happened yet. But she was certainly extensively cross-examined on her motive to lie, what she was expecting from the Commonwealth, and
Certainly, it doesn't seem to me that the defense is supposed to find out that a Commonwealth witness is going to assert the Fifth in the middle of cross-examination.
well, that was not ideal, but I don't think that the Commonwealth anticipated that happening either.
But did the Commonwealth, this is what troubles me about this. There was a cooperation agreement with this witness. I'm curious as to why it didn't cover this witness's conduct in apparently covering up evidence in the case. So the Commonwealth kind of got, it just seemed unusual that the Commonwealth got what it wanted out of this witness. And then once there was something that might favor the defense, this witness invokes her Fifth Amendment privilege, which should have been covered by a cooperation agreement. So I'm curious, why did the agreement stop short of that?
I don't think the agreement did stop short of it. I think it covered it, but it was not a grant of an immunity. So she still technically had a Fifth Amendment right not to testify about it, even though she had been promised consideration. She had not been granted immunity, so she technically still had a Fifth, and for whatever reason, she elected to assert it. And at that point, the Commonwealth is in the position of either we grant her immunity, which we didn't have any intention of doing because we already had a cooperation agreement, or we let it play out the way it did. It was certainly not an ideal situation, but I don't think the defendant was deprived of anything.
It's not ideal. It's not the way it's supposed to happen, right?
Right.
So when this has got to throw a real monkey wrench in the defense to the extent of, how you plan your,
Right.
and also for the Commonwealth, because they should have straightened out before they put that witness on the stand to determine whether she is going to be put on the stand. So,
These were some of the most difficult witnesses. I was the appellate chair at trial. These were, I think the prosecutor used the phrase, when you have a murder in hell, you don't have angels as witnesses. This really applied to this case. We had capiases out for all of these witnesses. We had to go pick them up and arrest them and bring them in. They did not want to be there. Even the one who had a cooperation agreement was incredibly difficult. So I don't know what more we could have done to prepare for this. This blindsided us as well.
That's what I wanted to make clear. So when you presumably had a proffer from this witness where she told you exactly what she was going to testify to, right?
Certainly we had prepped her, yes.
I'm sorry?
Yes, we had prepped her.
No, but was there a proffer from her as to this is what I will testify to?
No, we don't.
It's not?
No, we don't generally do that as part of an agreement. It's just, you agree to testify truthfully in this matter, we will take that into consideration in your case. So that's what we were left with.
So what's troubling me here, so I'd like to know, so what's troubling me here is on the prejudice piece of it. The contents of the phone seem to me, the contents of whatever the recording was on the phone,
Right.
seem to me that if they were, depending on what they showed, could have been highly pertinent.
They could have been?
They could have shown the defendant running away with a gun in his hand. They could have shown another person running away with a gun in his hand or her hand, right? So, or some other probative information about what had happened. And so when the defendant is precluded from inquiring at all into anything that bears on the criminal charges relating to the stealing of the gun, it seems to me that depending on how far they could have gone, so for, including, well, did you watch this video after you did you watch what was on the phone after you stole it? Could have been really helpful, or maybe not.
Her answer would have been, I don't remember, because that was her
Well,
answer.
we don't know, right? So can you talk about the prejudice? Because I get your point that they were able to inquire into bias against the defendant. They were also able to elicit the facts about the theft of the phone and the fight from the neighbor witness, all of those things. But it seems to me there is this sort of elephant in the room, which is what was captured on the phone.
Well, both neighbors were available to testify. Cynthia Martinez testified. Her husband was available to testify, who was the one who was taking the video. They could have been asked what was on the video. They were available. Ms. Martinez testified about the entire robbery. There was no reason that defense counsel couldn't have asked what was on the video. I think her answer probably would have been people running away. But I don't know, and certainly the husband was available as well. He was the one who took the video. So he could have been asked that as well. The thing is, you didn't have to get it, he didn't have to get it from this witness. And, cited within my brief, Commonwealth versus Farley, the court says, basically, look, even though you should have been able to cross on this, in that case, whether or not the witness was a drug dealer, you had someone else come in and testify that he was a drug dealer. So it came out. So the fact that she committed a robbery, the fact that they took the cell phone, the fact that the cell phone may have recorded people running away, that all came out at trial. And what was on the cell phone, defense counsel could have asked about that. So I don't know that the defendant has demonstrated any prejudice in the sense that if the video was exculpatory, he has to make a showing, that it would have been.
Can you turn to the first issue that the defendant raised, which are the questions that were posed during voir dire?
Certainly.
And correct me if I'm wrong, but no one's blessed, in this jurisdiction at least, no one's blessed the use of a question phrased. There were variations in the question throughout, but they all included the word convict. Would you be able to convict? Has anyone blessed that phraseology in a question? Now, let's just call it a CSI type of voir dire question.
So I think the closest you get is...
I didn't see anyone actually using the word convict.
No, there isn't. I think Andrade is the closest. Would it prevent you from finding the defendant guilty? I think, and when you look at the Maryland case, the court's concern in the Maryland case is the question was, would you be unable to convict the defendants? Basically, that the question assumed that the defendants must be convicted, and that they were basically telling the jury, look, the defendant's going to be convicted, but there's not going to be any scientific evidence. Do you have a problem with it? This question said, would you be able to? And in Andrade, the SJC said, simply because a member of the veneer answers that he or she is capable of returning a guilty verdict in the absence of eyewitness testimony, in that case it was the opposite question, does not mean that he or she will necessarily do so. And so I think that that's where this case really differs from the Charles case, and the cases where the question was held to be improper. And the jurors' answers, the jurors, particularly the ones who were seated, show you that they understood the question. Juror number 5 said, well, I suppose that could be compelling, but that juror didn't commit. The other juror said, well, if I found the other evidence credible, yeah, I guess.
When a juror says, in response to that question, when a juror says, I need something more, eyewitness testimony isn't enough, I need something more, is the proper thing to do to exclude that juror from service at that point, or is the proper thing to do to at least ask a follow-up question, such as, well, if the judge were to instruct you as a matter of law that you may convict based upon eyewitness testimony alone, would you be able to do that?
I think it's within the trial judge's discretion to do either, because if the juror said, I need more, and the trial judge observing that juror goes, this juror is not gonna follow my instructions.
I mean, my concern is these are lay people coming in to testify, and they probably have never given much thought before to direct evidence and circumstantial evidence and so on and so forth. So they're being hit with this cold for the first time. It seems a little unfair to exclude someone from service on a jury when they aren't given any explanation as to what some of these terms even mean.
Well, but I think the judge did, and a lot of the jurors who ended up seated, juror number 5, they said, I don't know, I've never really thought about it. And so the judge sort of, went further and said, okay, well, here's what the Commonwealth is likely to present. Would you be able to, return a verdict based on that evidence if it, and the juror goes, oh, well, yeah, that could be compelling evidence.
But some of the jurors who were excused for cause answered the question in similar ways. If the question was, would you require some sort of scientific evidence, some of the jurors responded, I think so, which to me is equivocal, right? And it does call for follow-up questions before you can excuse them for cause.
Well, I think so. I mean, there are plenty of jury selection cases where this court and the SJC has held that I think so. Some people go, I think so. Where it's not a question, it's not equivocation, and I think that's up to the trial judge. And you can see that here the trial judge is engaging with the jurors that he thinks can be engaged with, and letting go the jurors that he thinks are not capable of following his instructions or have other issues. And I'd say a lot, there were jurors who were excused on the CSI question and for other reasons. But I think the judge conducted an individual colloquy with each juror that was personal to each juror and based on each juror's answer. I'm happy to address anything else if the court.
Where do you think we would find the correct articulation of prejudice, assuming this was not structural error?
I think it comes from, I would say all the jury selection cases where the defendant has to show that that there was a juror on the panel that was not fair and impartial.
And in cases where that burden has been met, what was the type of evidence or information that satisfied that test?
In those cases, it was things like, because, jurors, Commonwealth versus Long comes to mind, where the juror basically says that he's a racist, and the judge says, can you put it aside? And he goes, I'm not sure. If you had a juror in this case who, I'm trying to think of an answer that would have put them in that box, but I guess I imagine there would be some answer that a juror could, you know, if
But
a
the
juror said,
prejudice
absolutely,
was-
I'm ready to convict him now.
The prejudice was shown through answers to the voir dire questions, not from other things that occurred later during the trial?
Usually, again, it's usually focused on, because, you know, if you have you don't have a juror who's fair and impartial, it's essentially structural error.
Yeah.
So there's not really an
So-
inquiry
so-
into prejudice.
You're saying that the prejudice inquiry focuses exclusively on the seated jurors?
I mean, so there is discussion in most cases where they suggest, well, if you've chosen a jury that's predisposed to, but if you've committed them to a verdict, then, and excluded all the jurors who won't commit to a verdict, that's one thing.
So that would be structural error?
Yes, I think you're getting into that area if you are committing them to a jury.
So just hypothetically, were we to find that the questions posed were improper and jurors were systematically excluded for cause improperly, that would be structural error?
I mean, I don't know if that's necessarily true in this case, because the structural error comes, I think that more lends itself to the prejudicial error standard, whereas if you have an partial juror on your jury, it's structural error. Everything else within, you know, within jury selection is, it's not exactly clear, I guess, from the case law.
Do we have any cases involving situations where there was an improper allowance of a for-cause challenge as opposed to the improper denial of a for-cause challenge?
You know, I can't think of one. I don't know. I imagine that if there was an improper allowance of a for-cause challenge, you would look to see whether or not the parties had peremptories left. I will say that there were 11 jurors excluded on this question, and the Commonwealth had used 8 peremptory challenges. So the Commonwealth only had 8 left. So you would be in a situation where if there was a juror who was improperly excluded for cause, you know, the peremptory challenges don't save you.
I just have one last question about, it's been said, I believe defense counsel had said, made a reference to the questions not being balanced or not being impartial. But would you agree that when these questions are being asked by the parties, that it's evident that the parties are not impartial, that they're asking questions because they want to make sure there are jurors who are not going to have a bias against their position? Would that be correct?
I mean, the parties are trying to make sure that the jurors won't, I don't know that they're looking for jurors who will decide the case in their favor, but they're certainly looking for jurors who won't decide it against them just because of a preconceived notion.
Well, and that goes to, I mean, they have an arsenal of peremptory challenges that can be deployed.
Right.
If the lawyers have a sense that their client might not be treated fairly by this particular juror, right? So there is some partiality in the process of asking questions. Would you agree?
Oh, certainly. I mean, that's what you're trying to ferret out, bias against you and against your client. So I don't think that changes the nature of the inquiry now, in terms of, you know, the trial judge was there to make sure that nobody stepped over the line, nobody committed a juror, and there was an instance where they were discussing questions, and the judge said, and I think it was actually one of defense counsel's proposed questions, he said, you can't act like, I'm not letting you ask that, that's committing them to a verdict. So he was on the lookout for that.
This is somewhat of a theoretical question, but if the SJC has expressed doubt about this CSI effect and called it speculative, why would it support a challenge for cause?
I
I mean, 13 jurors here were excused, I think it was 13, based on their answers to this question. But why would it support excusing them for cause?
Because similar questions, they have said, we're not sure that this is really necessary, but the trial judge didn't violate the defendant's rights. And in those cases, jurors were excused for cause.
Cause.
I didn't see in the record, well, I saw reference in the record to the fact that the Commonwealth's proposed voir dire was submitted in written form at some point, but I didn't see that in the appellate record. Would you be able to submit a copy of the what was submitted and what was filed down below, and the defendant's filing of proposed questions as well, or any response to the Commonwealth's written proposed voir dire?
Certainly.
Okay, I'd appreciate that. Let me see if there are any further questions. No, thanks.
Thank you.
Thank you both. It's a very interesting case. We've been aided by your excellent briefing on both sides and your able argument today. The case is submitted. The next case is 2021 P1115, Commonwealth versus Alexander Rosario. Attorney Contartesi.
Please the court, Adriana Contartesi for the defendant appellant Alexander Rosario, who contends on appeal that the evidence was not sufficient to support his identification as the shooter beyond a reasonable doubt. I think that my brief is about as exhaustive as it could have been on the issues. And the record that we submitted, that was submitted shows all the different videos that the Commonwealth put together to make its case to show that the defendant was the shooter. And while the defendant concedes that, well, there's no question that the evidence supported the fact that there was a shooting, although the evidence may have supported that the defendant may have been the shooter or might have been the shooter or could have been the shooter, that is really not sufficient to support that ultimate identification of him beyond a reasonable doubt.
Can you help me with the following? So there's the video from Superior Bakery vantage point that shows a shooting occurring. It's 3 people. The person, they're walking, it's the last one in line who's the shooter. Is that correct?
Yes.
Okay, and that person's wearing white sneakers?
Yes.
Okay. Then we have the videos from the liquor store. And those are from an hour earlier, is that correct?
Yes, and I think my brother got it right down to the minute at
Okay.
52 minutes, I think.
All right, 52 minutes earlier. At that point, there are 2 people who are captured on video. Is that correct, by the liquor store video?
Yes.
And I take it you're not challenging that your client was one of the people shown on the liquor store videos?
Well, that
was
identification of
established.
Yes.
Okay, that was
you can't really
established.
argue
All
about
right,
that.
that's fine.
But one thing that we did disagree on, the Commonwealth and I, was that the clothing that he was wearing in that video the Commonwealth described it as unique, whereas in my brief, I described it as very common clothing that pretty much all kids that age would be wearing.
And the difference being that that person, your client, at the time he's captured on the liquor store video, is wearing black shoes.
Yes.
Okay. And now it is unclear to me from the briefs what happened. Is there any evidence about what happened where your client was before he ended up in the liquor store? Was that just not part of the case?
No, I think that there was some evidence that the boys had been in a house at 57 North Warren Avenue.
Before going to the liquor store?
Yes.
And then what happened? According to the Commonwealth, what happened? In the light most favorable to the Commonwealth, which I realize is almost unfair to ask you, but let's just, because I'm unclear of what the sequence of events was alleged to be.
I think I'm going to have to let the Commonwealth answer that, because I could not tell you correctly with certainty whether or not the video caught the boys at the 57 North Warren Avenue address prior to or after the liquor store. And you know what? I think that is something I definitely would have known, and I would say that I don't think that the Commonwealth's presentation made that clear, although my brother might have something different to say about that.
Okay, so even without, so at some point there's video that shows them at a house at 57 Warren Street?
Yes. Or, no, coming out of a house.
Coming out of the house? And at that point, is your client wearing white shoes or black shoes?
The client is wearing black shoes at the time of the Fernandez family liquor.
Right.
At the time of the Fernandez family liquor video. At the time of the shooting, the shooter was depicted with white shoes.
Right. And in between then,
I don't know what the evidence, I can't tell you what the evidence
video showed?
presented, and I'm not sure that there was any. But I know that there was a discussion about the sneaker color coming out of the house, and that the Commonwealth made an argument that the defendant had changed his shoes while in the house, which is what was the basis of the identification of him being the shooter, because nobody ever identified him in the depiction of the shooting as the defendant.
This still photo at page 38 of the exhibits volume showing the shooting,
Yes.
which video is that from? Is that from the Warren Street video, Warren and... This is the clearest photo
Yes,
in the
that is
exhibits
the clearest
volume
photo. Yes, it is.
of the
Yep.
shooting. Which video is that from?
I'm sorry, I can't tell you that, but I can send that in
I
a
was
note.
unable to find this in any of the videos that were filed with us. This photo, I couldn't even match up the background in this photo with any of the videos that were submitted to us. So it would be helpful.
I spent a ton of time trying to get it right, so if there was a lapse, I apologize for it. I'll identify that photo, I'll identify the video that it came from, and I will pop that back to the clerk's office in a letter either later on today or tomorrow.
While we're on that subject, and maybe the Commonwealth might have the answer to this, but there's a reference to a map, and it seems that a number of witnesses were like pinning things on a map while they were testifying. And there is also a reference to a poster board, I believe, in the record, but we don't seem to have a map.
Oh, I could not find that poster board. I could not find that poster board. I think that it had been stored in a courtroom after that. It was very difficult to get all that, to get those exhibits together, and that was just the one thing I could not find.
For me, that's kind of a critical piece of if the Commonwealth is trying to establish a timeline here in terms of time and space, that having a map is pretty critical in
I
doing
agree,
that.
and because those inferences, as I went on exhaustively in my brief, all those inferences had to be, they could only be connected if there was a reasonable basis for it, and that was a reasonable basis. And so, as I said, it's very unusual in a jury-waived trial to have an instance where there might not have been exactly correct instruction. But this may be that kind of case.
Are you confident that all of the video files that were introduced at trial have been provided to us in the appellate record?
I am confident. I worked, it was so hard, and the clerk from the juvenile court was instrumental in helping me get the video from the DA's office, and I wound up having to provide special, really huge memory sticks so that the DA's office could put that information on those memory sticks for me, and then there was special software on those memory sticks that are required to run that video.
We have run into all, we've discovered all of that ourselves.
It was very, and I'm an appellate lawyer, and throughout this whole process, the only thing I could think of was how frustrating it must be for defense counsel to just get like a discovery dump. I don't think that that's fair at all. I would never do that in a, I hope I certainly haven't done it in this case, but in a case I'm presenting to one of the appellate courts, I would never not have my things organized, and I don't understand how the Commonwealth can just get away with dumping all that in those CDs that nobody ever can really figure out how to look at.
Well, I'll tell you, there was one file folder that was empty as it was filed with us. One video file folder came with nothing in it. Perhaps you could just double check after this argument and make sure that we did get everything, all the video files that were admitted.
I sent in a memory stick
Yes,
also, and I sent in CDs also.
Yeah, if you can double check, because
Sure.
I'll just tell you, which you won't be able to, the file folder on your flash drive that was called North Warren Ave, Spring Street, was, I believe, empty. Do I have that right?
Yes.
Yeah.
Spring Street, okay.
North Warren Ave, Spring Street was empty.
Nice.
If I could just note one more thing for you to check. Your brief says that the Lucroft Warren Avenue video series was shown to the jury
Yeah.
and was alleged to show the shooting. There's one video in that folder. So if there's a series of videos, we only have one of them.
Okay.
I did not see the shooting depicted in the one video we have.
Yeah, I think the two folders that are the most problematic for us are the ones that are, everything in the 20-416-AR folder is a little bit dicey for us.
Okay.
Okay? And within that, there are two subfolders, one being North Warren Ave, Lucroft Ave, the other one being North Warren Ave, Spring Street. They don't look complete to us.
Okay,
Just double
I'll
check,
take care of it.
yeah.
But may I just ask you, that was Exhibit 38, was a photograph excerpted from a...
It's page 38 of our exhibits volume. I don't know what the trial exhibit number was because it's not
That's okay, I'll
marked.
take care of it.
I was assuming from your brief when you said that the Lou Croft Warren Ave video depicts the shooting, that this photo was from that video, but it may be this is from the Superior Bakery video.
Well, I think one of the things is in the trial, the Commonwealth would say, go to like 10, 16, 07 of the numbers. So referring to different seconds on the security video. So they were running that security video for the jury, well, for the court, in a much different way than I was seeing it or trying to organize it. And if I had known in advance that the court was having a problem, I would have, of course, taken care of it. But I will take care of it.
I'll add one more
Maybe my brother will help
question
me.
For you on this. And this is not meant as a criticism in any way. It's really a question. I'm curious as to how things happened in the trial court because it's not clear to me. Especially when we're dealing with video exhibits like this, we should only be looking at what the trier of fact actually looked at. And it seems to me, I mean, there's a lot of videos that have kind of almost been dumped here into this record. And so, for example, like in the liquor store, there's video of the stockroom. I don't see what that has to do with this case, and I can't imagine the trier of fact was looking at the video of the stockroom. So I'm just curious, if you know, as to how that winds up in the record. In other words, is someone just taking what the police, their video dumps, taken all of that and made that part of the record appendix, regardless of whether that was in front of the trier of fact?
But if it was put into evidence on that, if that was on the CD that was put into evidence, of course it's before the trier of fact, even if it doesn't show it to the trier of fact during the trial.
I see.
If the trier of fact is taking it back to the deliberation room, that's fair game.
So that does answer my question. So there's likely a lot of immaterial video in here, such as like video of the stockroom and things like that really have nothing to do with the case, but that was part of what was presented by the Commonwealth, apparently.
Yes, and I have to make a decision whether or not I should show the appeals court a complete record, and I know that I'm not supposed to waste the court's time by presenting things that aren't necessarily relevant, but how can I assess what the trier of fact was looking at, and then perhaps risk having the appeals court say to me, why didn't you put in a whole record? It was extremely time-consuming, and I know it takes a lot of time for the court, but I could not think of a different way to do it that would not have been presenting a complete picture of the case.
I think we understand that. Let me see if there are any other questions for you, and I don't see any. Thank you very much. We have your
Thank you,
argument,
and I will
and we will
provide-
appreciate your help you can give us with the other.
In the meantime, I do ask the court to consider vacating that conviction. Thank you.
Thank you.
Good morning. If it pleases the court, Arne Hansen for the Commonwealth. With respect to the timeline, is that something that I may address now? So the defendant's movements that morning were tracked via the city cams that were in the city of Brockton. He's seen leaving the house on Warren Ave, going to the liquor store. The liquor store tag puts him at the liquor store at 10:01. He then walks.
First of all, could you please speak up? Secondly,
sorry.
Speaking for myself, we were hampered by the lack of citations in your brief to specific points in the videos, at like time points in the videos, and reference to the specific video. So I'm assuming you are unprepared to do that for us now during oral argument, and it would take too much time. But I'm going to ask that you send that to us after the argument within 5 days. For any fact that the Commonwealth is relying on to establish anything in the case, based on the video, we need a cite to the name of the file of the video with the timestamp, with the time reference, so we can move to that, because we were given a ton of videos, and I take it you don't dispute Attorney Contartese's representation that all of the files that have been transmitted to us were in fact part of the exhibits below.
No, Your Honor.
Okay, so we need to know what you're referring to.
That's fair.
Yeah.
I can certainly do that for the court.
We try to be fair.
Thank you.
Okay, so you have video, the Commonwealth had video footage showing the defendant leaving a certain house and then going to Fernandez Liquor?
That is correct.
Okay, and at that point, is he accompanied by people?
I believe he's with one other individual.
Okay,
They then return.
and is that the individual who's, in the Commonwealth's theory, also depicted on the liquor store?
That is
Okay,
correct.
and at that point, the defendant is wearing black shoes?
Correct.
Okay, so then what happens?
He walks back to the house on Warren Avenue.
And how much of that is captured on video?
I couldn't say for certain off the top of my head.
All right, am I correct that basically the only evidence of what happened is video evidence in this case?
Not necessarily, Your Honor. There are 3 witnesses that heard gunshots.
Yeah,
One of them, the front seat passenger in the car, Ms.
That's
Goncalves,
true.
saw an individual raise a gun, screamed, "There's a gun."
okay, so
warned the others in the
I'm going to
car.
rephrase my question because that's well taken. The only evidence of what the defendant, specifically the defendant did, his movements that morning, is from the video?
Correct. No
Okay.
specific witnesses identified the defendant on
Yep.
scene. He was identified through the videos.
Okay, so do you have a video showing that he left the liquor store and walked back to the same house?
That is my understanding of the evidence. I would have to review those videos specifically
Right.
and provide cites to the court.
Great. All right, and at that point, and he's with how many people at that point?
When he comes back out of the house, he's with 2
Oh,
other
no,
individuals.
when he's walking from the liquor store back to the house?
I couldn't say for certain without having to review that video
Okay.
again.
He's still wearing black shoes?
Correct. Then he comes out of the house shortly before the shooting occurs. They realize that one of the other individuals that he's with, that car has been vandalized by 2 other individuals. That is captured on the Brockton City Cam surveillance footage. I can again provide references to the court. They go back into the house that they came out of.
Is he still wearing black shoes when he sees the car vandalized?
I would have to confirm when specifically. I know at the time of the shooting he's wearing white shoes. I don't know if he had changed shoes when they came out and realized there was damage to his friend's car, or that happened after they went back in and came back out again. Then shortly after that, Detective Bell initiates a traffic stop on 2 individuals who were driving a Kia. It's unrelated to the vandalism of the car, but after review, the detective believed that those individuals he had pulled over were actually responsible for vandalizing that car, based on their clothing, build, and frame.
How far away is that from where the vandalized car was parked?
I couldn't say for certain without reviewing the evidence, Your Honor.
Okay. And what is the point in time at which that happens relative to when the defendant and the 2 other people walk out of the house?
I believe this is minutes before the shooting. I would have to review the videos as well as the timing or the testimony of Detective Bell. I'm not sure if he gave a specific time. But while he was conducting that stop again, I would have to refer to the transcripts. Within several minutes of that, they heard the gunshots up the street. So this is very, very close. I would say within 5-10 minutes. If 5 minutes may even be too much.
Had he already allowed the car that he had stopped to leave before the gunshots?
If memory serves me correctly, no. So what happened is the individual who was shot at, Josiah Belmont, pulled up next to that traffic stop, told Detective Bell, "Hey, those are my friends," The detective essentially told him to leave the area and not to interfere with his police work. Belmont then drove another minute up the street to his girlfriend's home, decided when he got there that he was going to go pick up his friends, the individuals who were in the car, turned back around, went back the way he came, down Warren Avenue, and that's when his car was shot at. It's my understanding that Detective Bell and the other officers that were with him were still at the traffic stop when the shooting occurred.
And just let me follow up with a question that I had asked defense counsel. A map would be pretty helpful to us, as I suspect it was helpful to the judge in making her decision. Do you know anything about the map?
I can certainly look into it and see if it's in our case file. If I do find it, I can provide that to the court.
So the other individual seen in the liquor store videos, the Commonwealth's theory is that is the second person, the middle person in the shooting photograph.
Correct. One of them was positively identified. With regards to the three individuals who were on the street at the time of the shooting, one of them was identified as Anthony Bynum, and the third individual was never identified.
I'm sorry?
The third individual was never identified.
The one who is identified is the one in the liquor store videos.
I would have to double check that. I don't want to.
I mean, I noticed that that person in the liquor store videos is wearing white shoes. And then in the shooting photograph, he's wearing black shoes. So is it the Commonwealth, was it the Commonwealth's theory that they kept the same clothes on but changed shoes, switched shoes?
Yes, I believe that was postulated at trial.
Okay.
Was there any evidence as to who lived at the house they went in and out of?
No. They never executed a search warrant at that location. And they never
No, but,
went into
I mean, you don't need a search warrant to have information about who lives at a particular house.
Right. I don't recall as to whose home that was and whether or not they investigated
But the
that.
Commonwealth's theory was that these two people went into the house after being at the liquor store. They changed shoes as opposed to changing clothes and keeping their own shoes,
Right.
and came out, and then one of them fired the shot.
Correct.
But we don't know whose house that was.
I do not recall off memory. I would have to check the transcripts to see if that was relayed to the court during the trial.
Was there any evidence that the defendant or the two other people knew Belmont?
Yes. So Belmont was familiar with the individuals who we believe were the ones that, they were the ones that were pulled over in the Kia. He was friends with them. He's, as far as memory serves me, and again, I would have to check it and reference it with the timestamps, the defendant and the other individuals that are involved, the defendant, Bynum, and the third individual are standing outside when the traffic stop
They saw the
occurs.
traffic stop.
So it is conceivable that they saw the traffic stop,
Okay.
saw Belmont stop at the traffic stop and then drive away, and that's how he's associated with them. Whether or not, Belmont did not testify at trial, so I don't know whether or not these individuals know each other. So there was no testimony with regards to that. But it was conceivable based on the evidence that they observed the stop and connected Belmont to the individuals in the Kia because of their observation.
And that's from the testimony or the video?
I believe it's from the video.
From the video, oh, okay.
I'd have to check the testimony again.
Yeah, we were hampered by not having sufficient record references, citations in the brief. I'm going to ask that you work with Attorney Contartesi in making sure that we get all the video files. Because as I said, there's some folders that don't seem to have anything. And what I hear her saying is she simply copied onto a flash drive things that the DA's office provided to her. So I think between the two of you working together, you should be able to make sure that we have everything that was presented as an exhibit below. And then if you could give us citations to every fact, references to the exact point in the videos you want us to look at, that would be great. And also the map, if you can find it.
Of course.
Yeah. Let me see if there are any other questions. No? I think we have your argument. Is there anything you'd like to add?
There is one typo in my brief that I realized after I reviewed it again in preparation for today. It regards my analysis of the Davis case, which the defendant relies on. So that was 487 Mass 448. I wrote that the defendant's conviction was sustained. I should have written that it could have been sustained based on the identification evidence. So the court overturned the conviction, but it was based on inadmissible GPS data, as well as potentially improper statements by the prosecutor in closing arguments, but they didn't really explore that because the GPS data was enough. They did rule that the identification information, so the video that was presented, additional GPS data that was admissible, and witness testimony would have been enough to sustain the conviction and would have been enough to sustain the defendant's identification. So I just wanted to clarify that. So I wrote in my brief that the conviction was sustained, and I should have written could have been sustained by the evidence presented at trial.
Okay. So that's on page 25, I guess, of your brief.
Yes.
Okay. Thank you for that. Thank you for that clarification.
Thank you. I have nothing further.
All right, thank you. The case is submitted.
Thank you.
And if it's possible for you each to get the additional materials we asked for within 5 business days, so a week, that would be great. But if you need more time, just let the clerk's office know. All right, thank you.
Thank you.
The next case is case number 2022P0715, Charles Sherman NEAL versus City of Boston. And after this case, for those of you who are waiting for the rest of the list, we're going to take a short morning recess. Okay, Attorney Maas, we are ready whenever you are ready.
All right. Good morning, and may it please the court. My name is Randall Moss. I'm an assistant corporation counsel with the City of Boston Law Department, arguing this appeal on behalf of the defendant, appellant, City of Boston. I was also one of the trial counsel in this case. The judge committed a clear error of judgment in allowing the plaintiff's motion in limine to exclude evidence about the family of the plaintiff's supervisor, in the case, the headmaster of the high school where the plaintiff was teaching.
I want to make sure I understand the record correctly. When the issue came up, I understood the counsel for the city to be saying that they had no intention of themselves eliciting this testimony from the witness. Is that correct?
For strategic reasons, we would not have asked the witness point
Right.
blank.
But what you said, so this isn't really a case about you being precluded from seeking to introduce information you intended to introduce. That's not what this case is about, right? Because you weren't seeking to introduce the information. This case is about whether the judge erred in requiring that you give sort of prophylactically a instruction to the witness not to volunteer the information if it's not called for, right?
No, the judge made a categorical ruling that the witness was not to mention the composition of her family. because that evidence was not relevant. It was a ruling based on Mass Guide to Evidence 401. And there's a citation, it's page 66 of the third volume of the trial transcript, where the judge says, the race of her husband is irrelevant. She shouldn't offer it. It's not relevant to whether she conducted herself in a particular way.
Okay, but whether that was right or wrong, you weren't intending to introduce it.
We were not tending to ask a question point blank
Okay.
about the composition of the witnesses.
So then where's the harm?
The harm, Your Honor, is that the witness herself was not allowed to reference it.
But she's not allowed to just give speeches on the stand. She's only allowed to answer questions. So if you weren't going to ask a question designed to elicit that information, where's the harm?
Your Honor, I also note a section of the plaintiff's examination of the witness, of the headmaster of the school, where she was asked whether she took the plaintiff's complaint seriously and whether she ever treated the plaintiff differently on account of his race. That's on page 54 of the fourth volume of the trial transcript. If there's any, the reason she couldn't get into it is she was barred categorically by the judge in allowing the plaintiff's motion in limine. That is the reason.
But that's
for
what
any
I'm not
gap in the
understanding.
record.
If you weren't going to ask her, right, you did not intend to ask her for the information. So the judge didn't preclude you from doing anything that you intended to do. On cross-examination, are you, because I didn't understand this from your brief, that you're arguing that the judge's ruling somehow affected the plaintiff's cross-examination of the witness. I didn't understand that from your brief.
The plaintiff's cross-examination, Your Honor, it's a bit confusing because the plaintiff did call.
Okay, so the
witness.
plaintiff's examination of the witness. I'm just puzzled because I read the transcript to indicate that you weren't intending to get into this at all.
We were not going to ask a question point blank, again, for strategic reasons, about the composition of the witness's family. But I've identified a point in the examination where that could have come up. The judge's ruling, again, was categorical, and he made that clear both in the sidebar with counsel and then in the two paragraphs in his order denying the motion for new trial, where he says, this is not relevant, it should not come in, and that's a ruling.
I know,
made under
but even,
401.
let's assume for the moment that the judge was wrong in his reasoning. But if it was nothing you were going to inquire into anyway, what difference does the error make?
You say that the city was not going to inquire, that the city wasn't going to ask a question point blank. It was going to ask her about it did in fact ask her whether she took the plaintiff's complaint seriously and whether she ever treated the plaintiff differently on account of his race. At that time, the judge had already made clear that she was not to bring up the composition of the racial composition of her family. And so there wasn't a further question to that point.
So what
But-
were you going to do? You didn't make an offer of proof there, so you didn't go up and say, well, now we'd like to ask her about the composition of her family? Is
There
that
was-
what you were going to do at that point?
We couldn't ask that because of the judge's ruling. The offer of proof requirement typically comes in the context of a direct examination where there's a lack of clarity about what the content of the testimony that is to be elicited would be. But here, I mean,
Well, yeah, but you could have asked for a sidebar and said, Judge, we just want to revisit this issue on that motion in limine because we think now it's reached a critical point in the trial where this is something the jury really has to hear, and this is what we would expect the witness to say if we asked this question. And then he could kind of, reconsider it at that point, couldn't he?
The city could have asked for a sidebar. We could have made this argument, but what the city did in this case was legally sufficient. It opposed the motion in limine, and then when the judge, after saying that he was going to think about this issue, called the parties up to a sidebar and said he was going to order them into the lobby and instruct the witness not to mention the race of her family.
What I heard
At that
the
point, it
judge
objected.
Yeah, the judge said go and basically tell her not to volunteer that, because there's both sides represented to the judge that they weren't going to ask a question about this.
The judge's instructions at the sidebar are not the model of clarity, and I make this point in the brief that 2 days earlier, he seemed not to understand what it would mean to give the witness instructions to this effect, and then just before the witness is called, he is then calling the parties to a sidebar and asking them to go into the lobby to give this instruction. But again, I would point to that language on page 66 of the third volume of the trial transcript, where he is making a ruling on the merits. It's categorical. The race of her husband is irrelevant. That's a ruling under 401. She shouldn't offer it. It's not relevant to whether she conducted herself in a particular way. And the comments about her not saying this in a spontaneous, it was insurance, essentially. And, having participated in that sidebar, I walked away with the clear indication that I was just not to get into this in any way. And that reading of the judge's comments is absolutely confirmed by his denial of the motion for new trial, where again, he directly confronts the issue of whether or not this is irrelevant and makes a categorical ruling on the merits. This is not to come in. I should stress this point. The judge had the opportunity in that motion for new trial to say that he thought this issue was waived or he didn't have enough information. He didn't say that. There's not a hint of waiver in that order denying the motion for new trial. There's not a suggestion that the judge needed more information. Instead, it is a full-fledged endorsement of the plaintiff's motion.
Well, it doesn't matter if the judge saw waiver. That's up to us. We look at the record to determine whether there was waiver.
I would say, Your Honor, that the judge who heard the arguments in support of the motion in limine, called the parties to the sidebar, heard arguments there, and then issued the order. He didn't think there was an issue with respect to waiver or lack of clarity or needing more information. It was from there and then into the motion for new trial, just a full-fledged endorsement of the plaintiff's motion in limine on the merits.
So can we turn to the merits of underlying your argument?
Certainly.
What is the basis for arguing that this information is relevant without resorting to, I don't know, stereotypes, assumptions? I think the underlying premise to your argument is that if a white person is married to a black person, they would be less capable of either retaliating against that person or discriminating against that person on the basis, another person on the basis of race. I think that's the underlying premise of your argument, and I'm wondering where that comes from. There's no scientific evidence in the record to support that, is it?
Scientific evidence, Your Honor?
Yes, that a person who's married to a person of another race is less likely to commit discrimination, to be, employment discrimination against another person, or less likely to retaliate against another person in a work context. Because that's the fundamental, I think that's the fundamental assumption you're asking us to draw, or upon which a claim of relevance could be based.
It's not likelihood or propensity, Your Honor. It has, as we explained in the brief, it has to do with the witness's intent, which is absolutely an element of both the discrimination claim and the retaliation claim, and an element of punitive damages. The judge instructed the jury that the jury would have to determine the motive, intent, or state of mind of Mr. Neal's supervisor or supervisors.
Okay, so you're saying that it would be a permissible inference that a person that this headmaster, is white, but married to a black person, did not intend to retaliate against a black teacher. That's a permissible inference.
It's a permissible inference, and then
on what basis?
Collaboration. I'm sorry, Your Honor.
Yes. How is that a permissible inference? How do those two things connect?
It's an enormously consequential fact of the supervisor's personal life, Your Honor. As we discussed in the brief, this is something that...
So if a person has, let's just say hypothetically, that a man is accused of gender discrimination or harassment in the workplace against a woman, and it's relevant that he's married to a woman. That would come out and be admissible to what? To indicate that he didn't discriminate against a female employee?
It would be admissible to show that he didn't have
So it would be good to have a
intent.
case that says that. Do we have a case, any case that says that?
I do not have case, but equally, the plaintiff and the judge didn't have cases supporting the allowance of the motion for new trial, Your Honor. I think this is untrodden ground from a case perspective.
Given the verdict here, I'm a little puzzled by the city's argument, because as I understand it, the conduct of the city here, well, I mean, the verdict says it was outrageous and egregious. That Mr. NEAL was treated pretty poorly by the school system. I mean, he was recovering from a medical treatment. I believe he was over 55. He had professional status as a teacher, loved the kids loved him, loved his job. He had a very good evaluation just before all this happened. So, you know, given that background and the pretty clear evidence that there was retaliation for the MCAD complaint at a minimum, through the written warning, the suspension, the termination, what difference would what difference would it make if there was evidence that one of his supervisors was married to a person of a different race?
I think it would have made, this court cannot say that the exclusion of such evidence would have been harmless. As I argue in the brief, there's, I think, general unanimity about the facts of this case. So much of this case was captured in emails that were admitted as exhibits. The testimony of the plaintiff largely mirrored the testimony of the headmaster and of other witnesses with respect to the facts that happened. What this came down to was really the intent of the supervisor. And in the brief toward the end of it, I think on the third to last page, I have a number of citations. I think it's up to 10, where the supervisor, the headmaster, was asked about her thought process in responding to the various complaints made by the plaintiff and whether she thought his complaints were reasonable or legitimate. And the judge's allowance of the motion in limine deprived the city with presenting valuable evidence about the supervisor's intent, which is absolutely an element of both the discrimination and retaliation cases.
So if she were married to a white individual, the plaintiff would be able to put that in? That's relevant?
I
mean, it's just hard to see how it's relevant without something establishing that it's a proper inference.
I would say, Your Honor, that no one would have moved in limine. Again, this started as an affirmative motion in limine filed by plaintiff's counsel. And the reason that the plaintiff's counsel moved in limine to bar this, I think, was precisely because they saw that it would be powerful evidence in favor of the city. And I see my time has expired.
Let me see if there are any other questions. No. All right, thank you very much. We have your brief, we have your argument. Mr. NEAL, we appreciate your coming to attend today, but you did not submit a brief, and you informed the court that you did not intend to submit a brief. Our rules are that unless a person submits a brief, they can't argue to us in court. But I'm going to check to see if we have any questions for you, and otherwise, and if we don't, we'll just leave it there and take the case under advisement. But let me just check to see if we have any questions.
May I ask a question?
Go ahead.
I did submit a motion last night. It was a motion to dismiss the appeal by the city, and it was a motion to sanction the city for fraud on this.
All right, well, we'll take a look at that when it reaches us. but thank you for letting us know. Let me see if there are any questions for you.
I have no questions for you, Mr. Neal, but thank you for coming in.
Yes, thank you. And with that, the case is submitted. The panel, so thank you both. And the panel is going to take a brief recess. We'll be back within 15 minutes.
session. Please be seated.
Good morning, welcome back. The next case on the list is 2021 P1147, Inland Commercial Real Estate Services versus ASA EWC LLC. And Attorney D'Amico?
Yes, Your Honor.
Okay, did I pronounce that correctly? Okay, thank you. We're ready whenever you're ready to go.
Thank you, Your Honor. So, good morning. My name is Howard D'Amico. I am counsel to the defendant appellant here. And for purposes of this morning, if I may, I think I'll refer to my client from time to time as European Wax.
Okay.
For purposes of both something to refer to, and it will give us an idea of what the business is, I think, as we discussed this morning. So if I may it please the court. So I think we're here this morning on what seems to me, from a further review of the case law just in the last couple of days preparing for today, seems to me to still be the case. 3 years later, coming through the system up to the appellate court on this issue of frustration of purpose vis-a-vis the governor's COVID orders. And I know in a few minutes we may get into the issues raised in the, I'm going to consistently get it wrong, but Lafort case. Issues raised in the Lafort case, where I think this court even effectively suspended this proceeding for a while we waited for that decision. And then that Lafort decision came down in early January. This court asked us if we wanted to submit supplemental briefs, and I believe I submitted a quick supplemental. I think there was that 4-page limitation, which was great, just right to it. And I think in that brief, we outlined, even when we had originally gotten the order, I think our office, my office, I perceived that Lafort was really not quite directly on point with regard to this case. And I briefly summarized that in that supplemental pleading. We can address that as the court would like to. But I think for purposes of my argument this morning, again, I've seen, right, the case that led out here is that Cafe Nero case coming out of the BLS.
Could I ask you a clarifying question? Your brief seems to be framed exclusively in terms of the judgment for possession. Are you challenging possession and damages, or just the possession?
We're challenging possession and damages.
And damages.
And damages.
All right, so you're arguing that your client should have retained possession first, and second, even if not, that the damages should be reduced?
Yes,
Okay.
yes, and I yes.
By the 3
Yeah.
months,
Pardon?
by the 3 months.
Yes, yes, and that may lay later into the issue is, to the extent we might be successful on the frustration issue, we've still got to cover a hurdle with the notice, that September 1 notice to quit. So yes, we are arguing that you wouldn't get possession and that you wouldn't be entitled to those 3 months, effectively 3 months of rent.
I just would appreciate some clarification, because I'm not sure I 100% understand your argument regarding the notice to quit. I take it you're arguing that the notice to quit was invalid. And exactly why? What created an invalidity?
Sure. So, Your Honor, our argument goes that if we're correct, if the frustration of purpose argument is successful, and you, if you will, knock out the tenant's obligation to pay, call it 3 months' worth of rent, the September 1 notice to quit, by the record, by agreement of everyone, is the only written notice to quit ever provided with regard to this effort to terminate the leasehold. So our argument is that if the 3 months are not valid, a valid claim for rent by September 1, and no question, we concede that 2 months would have otherwise been due.
Yeah.
Our argument, and Your Honor, I concede, from my side, this happened to be one of those areas of practice where I expected there to be more case law in my favor, frankly, on this issue of a commercial notice to quit would also have to be clear, exact, and succinct, like that stream of
So
cases.
I'm looking at the notice to quit,
Right.
and on its face, is your argument that on its face, it's invalid as a notice to quit? Or is your argument that because it identifies a sum certain that's due, it's invalid because it shouldn't have included the unpaid 3 months of rent? Or is your argument something else?
It's much closer to the latter, Your Honor.
Okay.
The argument would be, Your Honor, my view over the years would be that the notice to quit, I think it's important that the notice to quit says you owe us 5 months of rent and nothing short of that will do. If it didn't say that, I think I'd have a more difficult hurdle on this issue. But it seems to me that once the notice to quit says, hey, you owe us 5 and nothing short of that will cure your default, there's succinctness, there's specificity there.
Now,
and if
do
I
you
read-
have any case that says if the amount that the landlord alleges is due is incorrect in the notice to quit, the notice to quit is invalid?
So I think I've even referenced in my brief that there doesn't appear.
Right, that doesn't seem to be right. So let's say that
appear
it's.
to be right on my part. or-
Yeah, it doesn't, let's just
Correct, Your Honor,
take
that
this
I didn't see it
hypothetical,
first.
right, let's just take this hypothetical. Let's say commercial landlord sends a notice to quit to a commercial tenant and specifies $55,000 in your back rent. It's not COVID, it's nothing else, but there's an error in the amount, like in the accounting department, who knows, one check had been sent in, they lost, and it's not actually 55, and everything else about this, the notice to quit is identical to this notice to
Sure.
quit. So it says, you have to leave unless you make payment in full.
Sure.
And the tenant's position is, I don't owe you $55,000. I actually owe you $48,000. Can you give us any, I take it your position is that notice to quit is invalid because the number that the landlord was claiming in back rent was not correct? That's your position, and then I'm going to ask you for some legal citation that supports it.
So, Your Honor, it seems to me, in just for the moment, the several cases on this issue I've cited, but let's see if I'll be able in a minute to pull a couple more out from just practice. It seems to me, in your example, and bear with me, I'm going to try to watch my time. I had a case years ago, we owed $55,263.18 in back payment. We agreed with the landlord's attorney that was the amount, that they would accept the amount. We sent it to them overnight. They got it on the day with the exact amount. 3 weeks later, my client said, hey, Howard, I got the check back. It was mailed back to me. We found out the lawyer had sent it to the bank overnight, and 1 more day's interest had accrued. And so the bank said, we didn't get the correct amount. It doesn't reinstate. So, Your Honor, now, that's not case law. That's practice out on this side. So my view of the world is the answer to your question is, if it's $55,000, you could think of it with regard to mortgages and notes secured by mortgages, correct? Foreclosing. Judge Long in the Ibanez cases, particularly the second Ibanez case, there will be my cite in a minute. My view would be, if it says $55,000 and it's $54,900, I disagree with sending that other check back. If it's $55,000 and it's $54,900, I don't find that to be material. So I guess I would look to a test of whether it's a material difference. Here I find.
So it's not per se invalid. So I
way
guess
to your answer.
what you're saying is, but here, it's invalid because the number incorporated a demand for rent that legally should not have been owed because the purpose of the lease was frustrated during the COVID shutdown.
Well put, Your Honor. Yes.
Okay, so in other words, so the validity of the notice, your argument regarding the validity of notice hinges on whether or not we agree with you that the purpose of the lease was frustrated by the COVID orders.
Yes.
Okay.
Yes.
That helps
Your Honor,
me.
Very quickly on your 55 example, right, 55, 54, maybe not. If you invalidate the 3 months, that's 60%, right? 3 out of the 5 months, 60%. That I view to be material.
Could we turn to the frustration of purpose? So my understanding of this doctrine, first of all, it's narrow, which the SJC did say in LaFleur.
As it should be.
Right, as it should be. And my understanding of it is that if someone's successful in showing commercial frustration, what happens then is that the contract is terminated and there's no further obligation to perform. And I'm not aware of any case that says there's such a thing as temporary frustration.
Interesting. And I don't know that I'm going to get to it. The BP case, BP v. Sachs, just coming out of the land court late December. I can give you a cite to that in a minute. I believe, Your Honor, I believe buried within that is a reference to the concept, with all respect, to the concept that that's not accurate. That you could have a 10-year lease, have 4 years of ability to further the purpose, have 3 months or a year.
Well, okay, so let me give you a hypothetical.
And come back.
Let's say there's let's say it's a 10-year lease,
Sure.
and you have a severe weather event, and the power goes out for 1 month. And during that 1 month, your client can't operate its services. Under your rationale of the commercial frustration doctrine, the landlord would be on the hook for that month's rent because it would frustrate the purpose of the lease for that 1 month, right?
Absolutely not. That
Why
is
not? What's the
not my intention.
What's the difference?
The nature of the event, the uniqueness of the event. Every tenant would be in here with every construction project out in front of commercial businesses, interrupting their business. The nature of the event, Your Honor, or the distinction is the specificity of the event itself.
Does it matter whether it's, so in Judge Shin's hypothetical, and comparing it to our case,
Sure.
that they're both events that were out of both the landlord and the tenant's control,
Sure.
caused by non-parties to the lease,
Sure.
that had a certain finite duration.
Sure.
So what makes this case different than her hypothetical?
I suppose in some of the cases I've cited, what you really wind up looking to is the specific facts, the severity of the event. I thought it was interesting, it was in the BP case. There were these coronation cases referenced, right? From whichever king it was. The king was going to appear in his coronation proceeding and a person paid a higher rent to watch the coronation. And it was understood that. And then he got sick and he wasn't going to have the parade. The court literally said that contract, that person's purpose was frustrated, and they were no longer obligated to pay the rent because of the material uniqueness of the dramatic change in the ability to operate under that contract.
But
That was what
wasn't the
contract
change
was
in that
for,
case connected to the purpose for which the lease was entered into?
as is the case here.
Well, no, they didn't enter into this. COVID was not on the radar. At any, I think the closest you could say is I rented this space in order to operate a business, and then orders came down from the government that prevented me from operating my business during these 3 months of my 10-year lease. And that's enough to frustrate the purpose of the lease.
I would say that.
All right, I think that if there was a government order that lasted for 9 years or 9 years and 11 months, you'd have a much better case. And if the lease was a 6-month lease and it was shut down for 3 months, that would also be a better case.
I'm not asking to get out of the lease. I'm not asking not to pay
Right,
the
but
other 9
that's the
years.
point. I mean, normally in these commercial frustration cases, they're trying to get out of the contract because the contract has been frustrated, the purpose has been frustrated, right? That's not what you're asking for.
I'm only arguing that the purpose of the lease for these months was frustrated by an
Right, do you have a
event that the parties
case,
didn't anticipate.
do you have an appellate case that says there can be temporary frustration where you don't get out of the contract, you just get out of your obligations for a certain period of time?
And I apologize again. I thought in the last couple of days I've seen a reference to one if it wasn't necessarily a mass case.
Okay.
I don't know. Is that something you'd want a single case supplied? I'll leave that to the court. I don't have one off the top of my head that I can cite to. I do believe I saw at a minimum dicta that said you literally could have a portion performing, a portion suspended from frustration, and then you'd resume. And that
So
would
I
seem-
would say if you have a case, you can submit a 16L letter, but just check the rule on 16L letters, so it's just the case site. I heard you just to say that what you're saying is you're not arguing that the purpose of the entire lease was frustrated such that you lose the benefit of the lease. The purpose was temporarily frustrated such as you should be relieved, so that you should be relieved of your obligations for 3 months of it.
The period.
Okay.
I don't, Your Honor, and it sounds as though there's some skepticism to structurally whether the law can do that. It seems to me the law can and should do that.
Well,
under
it
the
seems to me
state.
closer to, you're essentially arguing not really frustration of purpose, but something closer to like an excuse to justify, a legal excuse that justifies non-payment for 3 months, or something like that. I don't know.
I'll leave that to the court, obviously, but I do believe I'm arguing
Frustration of purpose, yeah, no.
Can I make one quick point?
Yeah.
Thank you. And I just want to make, in response to your inquiry, one quick distinction that goes to that LaForte case and why I believe from the start it wasn't really a dead-on. In that case, that contract was the purchase of the business years earlier. And then there was a note related to the purchase, and they couldn't pay on the note. I found that to be more of the example of, that's not a frustration of purpose at all. The purpose was to buy the business. Here, the purpose is to operate. The coronation case, the purpose is to watch the king. I think I've matched that.
Okay, I think we have your argument. Let me see if there are any further
Just
questions.
have one question for you. If I just want to make sure I understand this. Now, the governor's order goes from March through June, but the non-payment is from March through September. So in other words, it includes a period that is outside of the scope of the governor's order,
Correct.
right? Okay.
Correct. Yes.
Now, does that fact weaken your argument in any way?
It does not, under the early discussion we had with regard to it being the notice, the only notice. If they had sent a different notice, if they had said 2 months, or after it was argued we can't pay the 3 months or we shouldn't have to, and they just said 2 months, I would have no case.
Okay, but apart from the notice issue, just in terms of the frustration of purpose issue, in other words, it seems there's a period with this non-payment of rent that's divorced of the concept of frustration of purpose. So what do we make of that?
With all respect, Your Honor, I perceive that to be a red herring. I think that if on March 24 he was 2 days or 17 years behind, that's a different issue than on March 24 and 25. Does he have a right, this court, to determine, that's what I said at the outset, does frustration of purpose land on this line of cases developed from 3 years ago? Your Honor, I think that it does. I think that whether he's delinquent before, delinquent later, may go to the issue of the enforceability of the notice to quit. But with regard to just the frustration, I think he could be delinquent before, delinquent after. I'm only asking you to determine that for those about 90 days, whether he was excused from paying based on a defense, if you will, of frustration of purpose. 265, second restatement.
Okay.
Your
I
Honor,
think
does
we,
that answer your question?
Yes, thank you.
Thank you.
think we'll have to leave it there. Your time is
Thank you very
up, and
much.
we have your brief and your appendix.
Thank you.
Is it Attorney O'Hara?
It is, Your Honor. Thank you.
Thanks.
Good morning, and may it please the court, Ryan O'Hara of Bacon Wilson on behalf of the plaintiff appellee, Inland. I'm accompanied today by Christopher Pearson, my colleague who is trial counsel. Your Honors, there's two equally strong reasons to affirm Judge Ritter's decision in the Superior Court here following the jury trial. The first of those is that even if you accept the defendant's argument as to frustration of purpose, or I would suggest as the judge analyzed it more along the lines of impracticability, the defendant is asking you to make new law in this Commonwealth surrounding notices to quit. But given where the argument I just heard went, I think I'd like to start with the affirmative defense itself. And the Lafort decision recently received from the SJC was incredibly helpful in analyzing this, because maybe for the first time in their line of cases on this subject, they really clearly articulated the difference between frustration of purpose, impracticability, and impossibility. Now, on the frustration of purpose point, my reading of that decision is that they make abundantly clear that frustration of purpose is frustration of the whole purpose. And they do so by citing to that coronation case. And I think that's a great example, because what was happening in those coronation cases was a one-time special event, a really unique, particular, one-off purpose that couldn't happen. Now, the reason those cases were different from impossibility is the apartment in question could still be rented. But because everybody understood it was being rented for one particular event, it would be like if the New York Marathon didn't go off one year and someone had an Airbnb to observe it and that had been discussed. That's frustration of purpose in this sort of context. Impracticability is more along the lines of what the defendant here was suggesting, that because of this government regulation for 3 months, it was impractical for them to pay the rent because they weren't operating the business. Well, Lafort speaks directly to that exact argument and shuts it down. It's critical here that you go examine the trial testimony from the defendant. All that was offered by the defendant at trial was a bare claim that because of COVID and the fact that everybody agreed for 3 months this business couldn't really operate, they were unable to pay the rent. Lafort says you need more.
So would Judge Shin's hypothetical of the storm and the lack of power, in your view, would that fall into impossibility, into the category of impossibility?
No, because impossibility speaks to the essence of the lease itself, where the essence of a lease for premises is renting the premises.
But if there's no power at the premises, because I'm sure that the lease contains a requirement of certain basic services.
And this, Your Honor, I think, not to avoid your question, I hope this is helpful in answering it, comes to where these questions of each of these three defenses are all highly fact-intensive. The cases say over and over that they're questions for the special province of the jury or the finder of fact. So here, the standard you're applying is clear error. So in the case of...
the judge didn't really make any findings of fact.
He made two foundational findings.
Well, I don't see them as factual findings. He relies on Section 7.3B1 of the lease, which we have, and it's a document. And then he notes it's a 10-year lease, and 3 months out of 10 years isn't substantial frustration. So that's not a factual finding.
Well, the cases seem to suggest that those exactly are mixed questions of fact and law in applying and analyzing these questions. And those are the exact sort of factors that in the few cases that address this are exactly discussed. How much of the tenancy it has been impacted by this? What is the...
But didn't the witness, the only one who testified, wasn't the substance of his testimony that they weren't able to operate but may be able to sell some products, and gave a number? And then the judge didn't really rely on that anyway, right? So
absolutely correct. And I apologize for stepping away from the podium.
No, that's all right.
But that's all that the defendant's testimony was COVID shut us down, I couldn't do anything, it made it hard to pay. What the SJC said in Lafort about impracticability, and this is a direct quote where they are quoting a treatise, simply positing two facts, that the pandemic has occurred and that a party finds it very difficult or even impossible to perform its contractual obligations is not enough.
I think the tenant has made very clear that they're not relying on impracticability. Right? I mean, we're only talking about frustration of purpose.
I think that it was phrased as frustration of purpose, but when you go evaluate the trial record and what the judge was analyzing, there's reference by the parties throughout briefing to cases that discuss impracticability, and it's treated roughly the same. But to the extent that we are only dealing with frustration of purpose,
Well, at least that appears to be the case on appeal, from what I understand from the argument and from the briefing, is that the only argument being made is that the purpose of the contract was frustrated, somehow, I guess, in its entirety, and all the consequences that flow from that.
in which case, Your Honor, I'd suggest that the case is even simpler, because we are talking about a 10-year lease with 2 5-year options, and we're talking about 3 months where the tenant, just for the purposes of this argument and the way the judge analyzed it, couldn't operate its business. That is not frustration of purpose in line with what the cases say frustration of purpose is, which is something that totally destroys the fundamental object of a lease, or excuse me, of a contract. And here, when you have a 10-year lease, and this is a point that I made in the briefing, so I don't want to belabor it, but that's an agreement between people to cover a long period of time where any number of things might happen relating to the tenancy, to the economy, to what the government regulations do in regard to a profession like this, forgetting even COVID. That's a decade of rights that are being fixed. And what we're talking about here is 3 months where, due to what everyone agrees was an extraordinary circumstance and nobody's fault, where the business couldn't be carried on. Now,
So I take it you would agree that if the lease were a 6-month lease, that would be a different situation, and there were 3 months shut down. Or if it was a 10-year lease and there's a government shutdown for 9 years and 11 months, that would also be a different situation. So are you arguing that the amount of time of the shutdown compared to the length of the lease is, dispositive?
I don't think the case law says that any one thing is necessarily dispositive, but certainly, Your Honor, in the instances you were just putting forward, I agree with everybody that the defendant would have a much stronger case. What I'm suggesting by saying that 3 months out of 10 years was not a substantial frustration of the purpose is because that's exactly what, to maybe clarify an earlier response to you, Justice Shin, that's exactly what Judge Ritter found as a factual matter. On a mixed question of fact and law, found that 3 months out of a 10-year lease were not a substantial frustration of purpose. Now, I'm happy to keep addressing these questions, but I do think it's important to spend a little bit of time discussing, let's say the defendant is right, that somehow, as a matter of law, the judge committed clear error and the tenant was entitled to be forgiven those 3 months of rent. That then, per the defendant's argument, leads to the whole case being dismissed. Because even though nobody disputes that rent after the shutdown, and in fact, if you analyze the record closely, some rent from before the shutdown was owed and comprehended in this notice, that renders the whole notice invalid. And that argument just does not, it is not consistent with Massachusetts law on summary process, which is almost entirely statutory with some common law overlays. So the starting ground for that analysis is the statute itself. Chapter 186, Section 11A controls how you terminate a commercial tenancy. And there's separate statutes for all different sorts of tenancies. But here, where there's a commercial lease, what Section 11A says, in paraphrasing, is the landlord's entitled to terminate in accordance with the lease. So what does the lease say here? And when you go look at what the lease says here, it says that if a rent payment is due for over 10 days, the landlord can provide a notice that there is an arrearage, and that if the tenant doesn't cure it within 5 days, that tenancy is terminated. Then the lease says that notice is only required for the first late payment. Otherwise, 10 days non-payment alone on a second instance justifies going to summary process, among other different remedies. So when you look at the notice here, on its face, it's doing exactly what the lease says. It's saying, you are in arrears of rent. Here's the figure we say it is. You have 5 days to cure that. By the way, here is a full accounting of how we arrived at that amount. What this notice is doing is apprising the tenant of their rights. It's referring them back to the lease. It's telling them exactly how long they have before that tenancy is going to be void and vacated. And that meets all the requirements that are set by statute or case law. Specifically, I'd like to direct you to some of that case law on notices to quit and when they're valid and when they're not. And interestingly, that case law comes up almost exclusively in the residential context, which on the whole, as a legal regime, is entirely more protective of the tenant than the commercial context. For instance, just offhand, in a residential context, tenants are entitled to bring counterclaims in summary process actions. In the commercial context, they are not, and that is by statute. So in the residential context, a notice to quit is sufficient so long as it gives a definite endpoint to the tenancy and is not somehow confusing or misleading in a way that's material, which, as set forth in the Cambridge Street case cited in my brief, that's 481 Mass 128, just from 2018, that's a material error or omission with practical effect. That's what makes a notice to quit invalid. So in some old cases, very old cases, there were notices to quit that had no end date whatsoever. Those were invalid. Those couldn't sustain an action. By contrast, there's one where the wrong party is named, but the circumstances made clear to the defendant that it was them. That notice to quit was upheld. And these are in the residential context. One case out of the appellate division is directly on point to this issue in the residential context. That's the 11 Everett Street case, and that's in the addendum we've provided to you at pages 73 to 74. That case directly says where a landlord has stated too much rent due in a notice to quit. They were just wrong. That notice to quit was not invalid. And if you think about the role a notice to quit plays in the entire summary process, timeline, which is complicated, but the SJC spells out very well in the Ed Jardy decision, a notice to quit is the very beginning of the action. It's not even the equivalent of a complaint. It's a notice. It's telling the tenant what you're being evicted for. It sets what the basis for the type of eviction that's going to follow is. It provides the tenant with notice of what the landlord's claiming so that they can prepare to defend it, to assert their rights. Here, this notice told the tenant exactly what the landlord was saying. And clearly the tenant understood what the notice was saying because they immediately raised what they believed to be an affirmative defense. And the law and the full regime provides that that's exactly how it's supposed to go, because then a court action is brought. So my brother's reference to the Ibanez cases and the foreclosure line of cases is totally inapplicable to this situation. There you're talking about divesting someone of title to a property without any judicial process under a statutory power of sale that requires strict compliance where there was no strict compliance. Here you're talking about a notice that is a precondition to a judicial action where the tenant can raise whatever affirmative defenses they like. And in the residential context where the tenants can bring counterclaims, this exact scenario is addressed. It's set out in Chapter 186, Section 8A, that the tenant in residential context can assert counterclaims. If they prevail, then there's a deduction made, they have a chance to true it up. And what that means is in those cases, almost inevitably, there's going to be a difference between the notice to quit and the ultimate judgment amount. But that doesn't render the notice to quit invalid, and there's absolutely no authority to the contrary. So it's, to analogize it very briefly, seeing that my time's running out, It's as though there were a requirement in a tort case that the plaintiff exactly, or take breach of contract, that the plaintiff exactly plead their damages correctly. And if at a trial, there's some affirmative defense that knocks out a portion, the plaintiff can't recover anything. They have to start the action over. That's not how notices to quit function. There's nothing in Massachusetts law that suggests to the contrary. And in the case here, where the judge made a definite finding of mixed question of fact and law, not committing clear error, but addressing the exact circumstances in the proper law, and found against the tenant, to then what basically would be required is for a landlord to predict affirmative defenses, account for them in advance, and forgive rent without ever going through a judicial process that's created by statute. I would suggest you don't make that change to our law. Thank you, unless you have any questions.
Let me see if we have any questions.
Just have a quick question. The Lafort case, that quote that you read to us, is it your position that that case really forecloses all questions about COVID, regardless of how the claim is couched, whether it be impracticability or frustration of purpose or failure of conditions or whatever you can come up with? Is that what you're suggesting, that the cases should be read broadly enough to cover all types of claims?
Absolutely not. The Lafort case is limited certainly to its facts. I'd suggest, Your Honor, if you go read those facts and the really detailed analysis the SJC did, you'll find that those facts are very, very similar to those we have here, but of course leaves open the possibility for cases on other facts relating to COVID.
Okay. Thank you.
Thank you. It's an interesting case. We have your arguments, and the case is submitted. And if you do decide to file a 16L letter, please file it within 5 days.
I'll have to figure out what it is first, and then I will.
Okay.
Thank you.
The next case is 2022 P0904. Carlos E. Lopez Rivera versus Stephen W. Stetson, MD. We're ready whenever you are, Attorney Black.
Thank you, and may it please the court. Andrew Black on behalf of Dr. Stetson. The motion court erred by finding fraud in the inducement of an arbitration agreement without evidence of misrepresentation. It did so by applying improperly a heightened special notice standard for the arbitration clause. That is, the court specifically required Dr. Stetson to have explained the arbitration clause in Spanish to Mr. Lopez, and the law is clear. There is no special notice requirement for arbitration clauses.
When you say the law in that sentence is clear, to which law are you referring?
That would be the Awua case and the St. Fleur case that's cited in the brief. I can give you the citation.
What do you mean by heightened notice? When you're using that phrase, heightened notice?
Well, the heightened special notice, that was really, I think, the two phrases that were used in the Awua case, which is the First Circuit case that was applying the law from the St. Fleur case. In that case, the district court, the U.S. District Court, had applied a standard, a heightened standard for the arbitration agreement by requiring one of the parties to either explain or point to or specify that there was an arbitration agreement. In that case, there was a contract that referenced something by incorporation, which included the arbitration agreement. In that case, the judge had said, well, that is the lower court judge had said, well, they didn't really know about it, so we're not going to apply there. And the First Circuit, applying Massachusetts law, said, no, that's not the case. In that case, when the party signs the agreement and there is an arbitration agreement, and unless there is fraud, duress, or unconscionability, then the parties are bound by that.
Let me ask you a question just for my own edification. Spanish-speaking patient goes to a doctor and for some procedure, and there are a variety of consent forms that the doctor or the patient needs to give consent, I think, right before most, if not all, medical procedures. So usually that's given in the form of written documents, consent forms, but I suppose it could be given orally. But in any event, let's just take as a hypothetical that there are written consent forms given to the Spanish-speaking patient, and those written consent forms are in English, and the patient doesn't understand English. Would it be sufficient, and the patient signs those, procedure happens, something goes wrong, whatever. Can the physician rely on those consent or waiver forms when they haven't been explained or translated to the patient?
Yes.
Is there authority for that?
Yes.
Okay.
So in Massachusetts, the Paulink case, as well as the Wilkisius case, go to that point. They're not specifically about arbitration agreements, but they're about contracts in general.
I'm talking specifically medical consent forms. Because it seems to me that if you're asking a patient for consent, the consent needs to be knowing. So I would be surprised to find a case, but I stand to be educated, saying that you could explain something to a Spanish-speaking patient in English, a language the patient doesn't understand, and then claim that the patient gave consent.
Right. I haven't seen that case, but the facts in this case are different because there was a Spanish-speaking person at the facility.
But there was no testimony that this form, arbitration form, was explained or translated to the patient.
The evidence was that a Spanish-speaking person was available, and the Spanish-speaking person had worked with the patient regarding other of the forms.
The consent forms.
And the judge so found. I'm sorry?
The consent forms.
Correct.
Right, so one would expect that if that had happened on this form, there would be an initial as well.
No, this form didn't have a place for an initial.
Yeah, no one doesn't look like, there's no testimony or evidence that this form was translated for the patient.
That's correct.
Okay, so I guess what you're asking us to say is that an arbitration contract is different than the consent forms, because if you have to translate the consent forms because you're looking for the patient's consent, and consent needs to be knowing, but for some reason you don't need to translate the arbitration agreement.
Your Honor, before the court is not whether or not the medical consents need to be translated, and I'm not saying that they do need to be translated. I'm saying that they were translated in this case.
Yeah.
So that issue isn't before the court. What is the arbitration agreement. And I agree with you. There's no evidence that specifically the arbitration agreement was translated.
The judge found that it wasn't after an evidentiary hearing.
That's fair.
So unless we were to determine that that was clearly erroneous, we have to accept that, I think, right?
And I'm not claiming otherwise.
Okay, so I take it that your case is, can a Spanish-speaking patient who signs an English language arbitration agreement that is not translated for him, and there is no reason to think he understood as a result, nonetheless be, as a matter of law, bound to proceed to arbitration?
Yes.
Okay. And your best case for that?
The one that's directly on point is out of the Eastern District of Pennsylvania. That's the Martinez v. Skirmish case. In that case, the plaintiff went to play paintball. The evidence was he did not read or speak English well. However, he was accompanied by friends who spoke and read English and could have explained the form to him. And in that case, the plaintiff chose not to have it translated by his friends, and the court said that it is enforceable. He signed it, it's enforceable. And indeed, that's the law in Massachusetts.
Did the fact about his friends, was that dispositive?
I don't know if it was dispositive, it was
I mean,
certainly
let's say
referenced.
someone shows up at a paintball facility or other type of recreational facility, doesn't speak English, has nobody with him who speaks English, and signs a form, arbitration agreement. Is that a valid agreement?
Yes. Although we don't need to go that far in this particular case because there was someone available, and the judge even found that had Mr. Lopez had questions about the form, he could have asked. That's in her.
But that's not, you're not saying that's required, right? I mean, what if
saying it's
someone
required.
comes in and speaks a language that's not as common as Spanish?
That's right. So that's exactly right. It's not required, and someone who speaks a language that's not as common as Spanish is certainly entitled to medical care, and you would hope that they would be able to receive medical care. In order to do that, they would need to receive the forms. Typically, these forms are available ahead of, for non-emergency procedures as this was. They're available ahead of time. You could take that to whomever, have it translated, and come back and have understood the forms.
Let's say there was an affirmative representation from the doctor's office that these are all medical consent forms. Would that make a difference?
It may, because that may rise to the level of fraud. I'm not saying it necessarily would, but depending on the facts, it may. That's not what happened here, and that's not what the judge found.
So when she found that he was led to believe he was signing consent forms, you take that to be saying that based on the fact that there was a stack of forms placed before him, some of which were medical consent forms, that's what...
I believe that that's explicitly stated in her opinion, and I also think there's no evidence in the record from which you could find otherwise. So there would be nothing else to point to other than that.
Does there have to be a genuine meeting of the minds between the physician and the patient as far as the arbitration agreement goes? And the reason I ask that is this. You have the patient coming in as a medical problem, wants it resolved by a physician. It's the only person that can do it. On the physician side, you've got the physician's interest in the medical consent and so forth, so there seems to be some mutual concern there. There's some overlap. But the physician has another concern that the patient is probably not even thinking of, and the physician's thinking of, well, going forward, I don't want to wind up in court over this. And so I'm going to throw in some forms that are going to include the arbitration, the choice of law, financial responsibility, notification of employment implications if you have the procedure, data collection, and so forth. So the physician's got a lot of other things on his or her mind when the patient's coming in just looking to get help. So in that context, is there really a genuine meeting of the minds here when there's an agreement for arbitration?
I'd answer it in two ways. One is, the case law is clear that when a party signs a contract, he is agreeing to that contract, and that's the Paul Inc. and the Wilkisius case. But specifically for medical forms, these are forms that would be available to the patient, and in this case were. This was not an emergency case. The patient, if he so chose, could have taken them anywhere to get them translated. And in this particular case, he could have simply asked the Spanish-speaking employee of the facility to translate this. He chose not to. And he signed it. So yes, in this case, he is bound by his signature. I did want to just address briefly a few other things. The issue of unconscionability was raised in the motion papers, but the judge did not find the contract, the arbitration agreement, to be unconscionable. In order to do so, the judge would have needed to find it both procedurally and substantively unconscionable. And in fact, arbitration agreements are favored under the law. There's a statute on point, and they are generally enforceable absent fraud, duress, or unconscionability. And so I ask in this case that the agreement be enforced. Thank you, unless there's other questions.
I just want to ask you a question about that point, which is, I guess that's an alternative argument that you're raising, which is even if we let that, well, I just want to make sure I'm understanding. Are you suggesting that if we were to agree with you that the judge erred in finding fraud in the inducement, we would then reach the question of unconscionability because it was raised below?
I don't think you could because the judge didn't find it. But I just wanted to address it in case it came up during the second part of the argument here.
Okay.
But I think the motion judge would have needed to have found.
We would, so that would be remanded for that question?
I suppose if the court
agreed with you that it was not fraudulently induced.
I don't think so, because I think that the lower court judge would have put both of them in. There would be no reason to just find one. Judge could have found both and did not, just relied on fraud. And that was solely based on this heightened special notice standard for the arbitration agreement.
Okay.
Thank you.
Thank you. Is it Attorney Scott?
Yes, Your Honor.
Okay, thank you. Sorry.
Thank you, Your Honor, and may it please the Court, I am Robert Scott. I am here on behalf of the appellee. I stand to be corrected, but I think there is a procedural question here where I disagree with my brother, and I think for the Court. This is a summary process hearing. It is akin to summary judgment. Appeal of summary judgment is for de novo review. This Court can rule based on, you have the complete record, you have the transcript of the hearings, you can rule on whatever grounds for or against my client.
As long as they were raised below, I think. I don't think we get to just go arranging around finding issues.
The Court states very clearly that an arbitration agreement is a contract. And like any contract, it's subject to be invalidated by fraud, duress, or unconscionability. So
are you suggesting then that were we to conclude that the record here did not make out fraud in the inducement, that we would then need to consider unconscionability and duress?
Yes, Your Honor, and I would argue for unconscionability.
Right, because I don't think there was really anything in the record to suggest duress.
I'm not going to
Okay.
make a
All
duress
right.
argument.
But that issue wasn't raised in your, well, it was, I don't think it was your brief, but the brief that was filed on behalf of your client.
It was not raised in my brief, Your Honor. It was before the court below, and as I say, this is a de novo review. This is as if you were the trial court. So I do not think, and a trial judge can easily say, well, Mr. Scott, you didn't raise unconscionability, but I find this to be unconscionable. There's no...
Well, let me ask you about that, because as I read the record, the judge made some specific findings of fact. Number one, no one told the plaintiff that he was signing an arbitration contract. Number two, the plaintiff lacked an understanding of English to read the contract. And number three, the plaintiff was led to believe that he was signing medical forms. Now, the judge made that determination based upon the testimony that she heard. How could we make that any kind of factual determination like that without seeing witnesses testify?
Well, first of all, of course, I believe that I would argue that you should uphold that finding. It is, I would say, the most solid finding, that he thought he was signing a stack of medical forms. He needed to sign these forms to get the treatment, and that it was fraudulent in the sense that he had no idea whatsoever what he was signing, and was not in a circumstance where he should know what he is signing. But Your Honor has the transcript. You have 100% of the hearing. Now, it's true you don't have the opportunity to observe the demeanor of the witnesses. But as I say, when we have, I do much more summary judgment practice than I do this type of summary process. But the law is clear that it is on the same footing as summary judgment. And when I'm arguing summary judgment on appeal, the road is open to every argument that the evidence will support.
Well, that was raised. If it was preserved or raised,
Well,
there can be appellate waiver and there can be waiver down below
yes, Your Honor, and I suppose you could rule that we've waived that argument.
on appeal.
If I may move on.
All right, so may I ask you a question? Because
Yes.
I'm looking at RA 154, Record Appendix page 154, which I think is the patient arbitration agreement. And in the last paragraph, which is entitled Consideration, but the last sentence of it is, patient has read, understands, and had an opportunity to refuse to execute this arbitration agreement and agrees to be legally bound by its terms. I understand the judge's findings. She didn't make a finding, though, to the contrary, that the patient had the ability to refuse to sign this document. And what weight, even regardless of that, what weight do we give to a representation such as this in an agreement that someone has signed? And do you have any, and then a third question, just to make it even worse for you to answer, do you have any case where there's been language like that in an agreement that was signed by a patient or by a person who did not have the language skills to understand it, and it was nonetheless enforced or on that basis invalidated?
I don't believe I do, Your Honor. And if I may elaborate, a little bit of a digression. I have a client who signed a purchase and sale agreement for real estate. As you all probably know, purchase and sale agreements are long and have a very fine print. He knew that he was signing a contract for the purchase of real estate. Forget what number clause it was, but buried in that document was a provision which he was not aware of, which basically it was the commonly known plot plan provision, where it's basically where the signer represents that he has looked at the plot plan and knows what he is buying. He knew he was signing a purchase and sale agreement for real estate. He is bound by every word in that document. So to move it into the context...
Right, so actual knowledge of the content doesn't matter of a contract. Normally, right, the burden is on the person signing it to not sign something they don't understand.
And, Your Honor, I mean, I'm moving in my brother's direction here, but even if there's a language barrier, if you know the nature of the document, then, so if you know you're signing some type of an arbitration agreement that would take a dispute into a different venue and that would basically deprive you of your right to due process, if you have any reason to know that, or that is if you've been informed, or if you're in a circumstance where you should know that. So if he has a stack
Well, he knows he's being asked to sign important documents. He knows that. It's not like it's mixed in with a bunch of supermarket receipts. He's being asked to sign documents that pertain to his medical care, and also those documents include provisions regarding his legal rights.
Yes.
So those, and restrictions on his legal rights.
Yes, Your Honor.
Including restrictions on how much he can recover and where. And so the question is, and presumably, given the state of the evidence, those provisions were translated for him, because if they were in the documents that were initialed, it doesn't seem to be a dispute that he was given a Spanish language recitation as to those.
There is actually nothing in the record that, from a recipient witness, to say that anything was translated for him. And this gets into the missing witness.
But they have the practice of the office, and they have...
Yes, and they have my client saying, I knew I was signing a stack of medical forms.
Yeah.
So, and I agree with Your Honor's analysis up to a point. And of course, I think that's the problem here. So, when a person signs an authorization for surgery, that is a renunciation of legal rights. If someone operates...
Certainly a renunciation of a lack of consent to the battery of the surgery.
It's battery it is battery if it's not consented to. And so the patient knows that he is signing papers that the doctor needs him to sign in order for him to have the medical care. And I think one of you made that point, that that's why he's there. He's there for medical care, and that's what's on his mind. So the question is, and I think Your Honor sort of put your finger on it, he's signing documents that pertain to his medical care. The arbitration does not pertain to his medical care.
But not everything even in the medical documents pertains to his medical care in the sense that they have to do with the procedure, because even some of those consent forms have limitations on legal rights provisions.
Right, they deal with potential complications, but they're all tied into the medical treatment. There's nothing in there that pertains to a legal dispute or over whether or not the procedure was performed properly.
No, I thought there were provisions talking about where the case has to be arbitration has to be filed. Right, it has to be filed. I thought it was in Florida versus Massachusetts. There was a limitation of liability provision. Right, that doesn't have to do with medical care.
And if he was informed of the nature of that document, then it's proper that he signed it.
Why isn't your argument foreclosed by St. Fleur?
Excuse me?
St. Fleur, the SJC case that was interpreted by the First Circuit in AWUA, where AWUA, the First Circuit said that Massachusetts law does not impose a heightened notice requirement for arbitration agreements, and if it did, that it would be preempted by federal law. So how do you get around that?
Because this judge did not impose a heightened standard. This judge was going with black letter contract law. You have to have some understanding of the nature of the document that you are signing. And that's the problem here, Your Honors, is that there are two percipient witnesses as to whether my client knew what he was signing. One of them is my client. You have his testimony, I had no idea what this was. The other one
Wait a minute, let me ask you about that, because I've read his testimony very closely, and correct me if I'm wrong, but he never testified that he was misled by anyone. I mean, it seemed like it was very, to the extent he could remember some of the details, he seemed to be very candid and forthright, and he wasn't, trying to fudge anything, but he never came right out and said that he was misled. There was no testimony from him that someone, put something in front of him and suggested it was something that it was not. Am I right about that?
Well, he did testify that he was given a stack of forms to sign, and that the representation was made that these were necessary for him to get the medical treatment.
Okay, but there's no misrepresentation in any of that, is what I'm saying.
He didn't stand up and say, make the accusation.
Right, okay, and I interrupted you, so that's one witness. Now, who's the other one?
The other one wasn't a witness, was never called, was Beatrice LaFontaine, who, according to them, speaks Spanish, okay? That's hearsay. There is no evidence that this is the person that was supposedly available to translate for him. But we don't have her testimony. We didn't learn this person's name until the hearing, okay? So we had no opportunity to call her. But this is the person who reviewed the forms with him, who, if the arbitration form was explained to him, would have been the one to do it. Ms. LaFontaine, there's nothing in the record to say whether she's deceased, whether she's living abroad now. There's no explanation as to why this person, whose interaction with my client would be the smoking gun, why she isn't called.
Why does that matter?
Well, it mattered to the judge because this is the missing witness instruction.
Okay, but we don't need any kind of jury instructions in the context of motion to compel arbitration. We don't need a missing witness instruction or any other kind of instruction.
Well, that's true. That's for trial. But this issue will never get to trial. You are the finders of fact, or, if you will, the judge below is the finder of fact. She cites the fact that this missing witness did not testify.
Yeah.
And it's very significant because the only thing they have to show that he had some concept of what he was signing is circumstantial evidence.
But I'm sorry to take you off that path. Can we just see if we agree on what the elements of fraud in the inducement are? Would you tell me what the elements are?
That he wanted and needed medical care, that he was given a stack of forms to sign that he said and informed or that he had to sign these.
I might be wrong. Maybe my question wasn't clear. The legal elements of fraud or fraud in the inducement in this case. What are the legal?
Misrepresentation.
Okay.
Okay.
Reliance
thereon.
On the misrepresentation and harm.
Resulted.
And harm. So what is the alleged misrepresentation here?
The misrepresentation, be it intentional or unintentional, is the giving of forms for him that he needs to sign in order for the doctor to do the surgery, that he understands these are medical forms.
Okay, and then the reliance is he doesn't identify anything he relied on. So
Well, he relied on the representation that these were medical forms.
I didn't see anything in the testimony that anyone told him specifically anything about this particular document.
That is
No
correct, Your
one,
Honor.
no one described it to him. There was no affirmative misrepresentation about this document to your client.
There was an affirmative representation about the documents as a class, as a category, or a stack
These
of
are documents you need to sign. Let me see if there are any further questions.
Assuming that's true, what you just said, that he's given these documents, these have to be signed, how do you get around this? And this is the case that your brother counsel was referring to, the Wilkisius case from 1927. The general rule is that in the absence of fraud, one who signs a written agreement is bound by its terms, whether he reads and understands it or not, this rule applies to a person who cannot read. So
I agree with that.
that's a pretty tough rule to overcome, isn't it?
I think I endorsed that earlier, Your Honor. If you know the nature of the document you're signing, and you don't read all 20 pages of fine print, or if it's just a one-page document, if you do not read or you do not take steps to find out more about that document, but you know the nature of the document. And so here, the misrepresentation or the fraud is in the nature of the documents. I see I'm out of time. Of course, I could go on.
Let me just
but
see if
sorry.
there are any further questions. No, thank you. I don't see any. Thank you both for your very helpful briefing in this case and your able argument. It's an interesting case, and we appreciate your help with it. The case is submitted. Thank you to our court personnel for all their support in this sitting, and with that, we are adjourned.
Thank you, Your Honors.
Oh, sorry.